The gift of estate planning. Happy holidays! You can subscribe to our channel, Balcostics Ltd, to get notification on relevant legal and research topics. It's the season of giving, and in keeping with this theme, we examine the gift of estate planning. Estate planning allows you the chance to determine the direction of your legacy even after your physical life has passed. When you plan for your future, whether it's your potential incapacity or inevitable death, you spend time thinking about who and what you love. Questions such as, who is most important to me? Who will miss me most if I am not here to take care of them? Who will take care of my children or grandchildren? Having a valid will is very important in estate planning. The benefits of this cannot be emphasized enough. With a will, you are in a position to direct the administration of your assets after death and ensure that your assets are distributed according to your wishes. It is essential, however, that your will be properly drafted and executed to ensure that your desired objectives are fully and effectively met. A careless error could mean the difference between a valid will and an invalid will, or an effective and an ineffective gift. When a person dies intestate, that is, without a will, his or her estate will be distributed in accordance with the law, and their assets may fall into the hands of persons they never intended. The Intestate's Estate and Property Charges Act, Section 4, sets out a table of distribution of the intestate's estate after the payment of funeral, administration expenses, and other proven debts and liabilities incurred before death. First in line is the intestate's surviving spouse, which includes the common law spouse. Next in line are children. If there is a surviving spouse, the child or the children share only in a portion of the estate. However, if there is no surviving spouse, the children are entitled to the entire residuary estate. Third in line are the parents of the intestate, who become entitled to a share in the residuary estate only where there is no child or no children, and then they share with the surviving spouse a third share. Where there are no children and no surviving spouse, they take all the residuary estate. If the intestate leaves none of the above relatives, then other eligible relatives will inherit. Also important to note is the fact that where the intestate leaves no surviving spouse, children, parents, or other eligible relatives, or if any of them defaults in taking an interest in the estate, then all the residuary estate goes to the government. When you plan your estate, you are showing your whole family that you love them so much that you want to save them a great deal of the stress and strife that can occur when someone dies or becomes disabled. Speak to your attorney about getting your estate in order. Until next time, stay in the know. Credits produced by Balcostics Ltd. Written by Abi-Gaye White Thomas, attorney at law. Read by Kimeisha Simpson. Audio editing, Nicholas Bent. Today's episode is sponsored by Balcostics Research for all your data collection, analysis, and data visualization needs. Email queries to law@balcostics.com.